Hey folks, Mark Scroggins with Scroggins Law Group. Wanted to continue our talk about just because you can doesn't mean you should. So one of the biggest areas over the last few years that you see in decrees commonly or SAPs or orders are the ability to communicate with the child electronically. Okay, so used to be that was just a phone call, but now that includes FaceTime and any assorted other ways of communicating with the kids. Generally, a court is going to put limitations on that, but sometimes there are no limitations on that. So does that mean that you should be blowing up your kid's phone while he or she is with baby mama or baby daddy? No, you should not. That is not going to be something that is going to be looked on positively by the court. Let's talk about something else that is not looked on positively by the court. Do not grill Junior when they get back from the other parent's house to find out, well, what'd you do? Who'd you see? What'd you eat? What time'd you go to bed? Did you play video games? What kind of video games did you play? What was dad up to? Was he drinking? Was he smoking weed? Was he out with some friends? Was he out with a girlfriend? These are all things that are off limits, okay, when talking to your kids. Now, is there a specific prohibition that you can't do that? Typically, the answer is no. But how is it going to be viewed by a court? Poorly, okay? Kids need to be able to be kids and not be pawns in the chess game of child custody. So just because you can doesn't mean you should, and you really shouldn't.